Coming up on second session, Judge McNally sentences 2 men for drag racing. Judge Aquilina and Judge McAfee hold bond hearings. Judge Middleton holds a sentencing hearing on drug possession and impaired driving. And in a feel-good moment, Judge Wolfe oversees an adoption. We've got lots to see today, and I think Ellie's ready to go, so let's head into court. Good day once again, everybody. Welcome to second session. Let's get started straight away with Judge Middleton.
This is file number 26339, People versus David Ken Kiewit. It's here with his lawyer, Mr. Tim George. Also present is prosecuting attorney Deborah Davis, assistant prosecutor Elena Frazier, and Priscilla Walton is here from the probation department. She prepared the summary screening report in this case. It has a FY suffix, which stands for felony. It started out as a possession of cocaine and a possession of other controlled substance, which would be fentanyl, and operating while intoxicated. In this case, it appears the intoxication was by a controlled substance. Another case, I'm not really sure what to do with this. Mr. Kiewit almost left this earthly coil on the date of this, which was last November. I still haven't exactly figured out where you were going. It was like 6 o'clock at night, and you hit some trees and about killed yourself. Your blood alcohol came back as zeros, which was a surprise to me and probably everybody else. You had possession of fentanyl and possession of cocaine, crack cocaine. I didn't see any blood report that showed fentanyl or cocaine in your bloodstream. If it was there, I couldn't find it.
Your Honor, if I may, if there is an MSP lab report regarding that,
Let me look.
and send it to Mr. George. Did you get it?
I have it.
Okay.
What's the date of it?
Date completed January 9th. Let's see what day they sent it.
I have the one that shows no alcohol, and I have the one that shows the analysis of the substance.
It looks like it was sent out for discovery on 7/1, and it indicates there was the metabolite from cocaine and cocaine itself at 28 nanograms per milliliter and fentanyl at 1.6.
And also benzos.
The benzoglycanine is the, what I understand is the metabolite from cocaine usage.
Okay.
Thank you.
Let me look again. I'm not crazy. I might be crazy, but these. All right, thank you. All right, so having that information, Mr. Kiewit really doesn't have much criminal history. He has the telephone call case, and then he had the case that sent him to prison. He didn't go to federal prison, he went to state prison, and which turned his life and his family's life all upside down. Things have never been quite right since then. He's 11 years younger than I am. He looks 11 years older than I am. And he's trying to make his way in the world. Mr. George, what would you like me to know?
Thank you, Your Honor. And I know sometimes it can be routine for us to say, you know, it's fortunate that nobody was killed, either my client or anybody in the community, but that is truly the case here. You know, my client, you know, in talking about this, it was a scary situation. And you know, he was admittedly, I think on the interview that he did with Ms. Walton, he was acknowledging, you know, the substance use was to help to try to treat some of the medical issues he's going through. Obviously, the court can see my client is dealing with some medical issues, really has a hard time getting around. But at the same time, you know, that prior offense was, you know, about 30 years ago. He did do some time in prison and hasn't really had anything to speak of in the meantime. You know, I advise my client that this court would likely put him on a term of probation. He's willing to comply with what this court wants him to do. You know, even if that's something where it gives him an opportunity to maybe address some of the pain issues that he's dealing with in a different way, I think that would be beneficial. As the court can see, I don't believe that my client has a prior controlled substance conviction. If the court were inclined, we would ask the court to use the 7411 as part of the reduction of the count one in this case. So really, I do believe that the recommendation is appropriate, but we would ask the court to consider whether this is something that can be done in 12 months instead of 24. My client has indicated that he's basically just going to try to stay at home, stay out of trouble, and do what this court wants him to do. Thank you.
Mr. Kiewit, do you have a source of income?
A disability.
I think you told me that before. Do you have any income off your property? You said you were selling hay. Do you have any?
My son, I work with my son, but I don't get the income from that. He's doing the work. He has another job. So if I can ride a tractor and help him, I do. My father did the same thing for me.
Yes. Now, you're not on your parents' farm. You're down the road.
No, we're still on the parents' old property. They sold 2/3 of it, and they kept 40 acres and a couple barns. And I live a mile down the road from there. And I farm. Tyler farms 100 acres across the street from my house.
All right. Now, this is operating while intoxicated. You're going to lose your driver's license, which is tough for a guy who lives out in the country. And I'll go back to you in a minute. Ms. Davis, we'll hear from you, and then Priscilla.
Current review of the file and Ms. Walton's report, I agree that I think the defendant is underreporting the extent of his usage of substances and his use of alcohol. Yes, there was no alcohol in the system at this time, but there certainly was a large amount of cocaine and the metabolites indicating that he'd been using more than just once or twice a week like he was reporting. That being said, his medical conditions too, the combination of those things and operating a motor vehicle are just not conducive to a safe society. And I understand that he lives out in the country and we don't have a lot of public transportation options. But when you're operating a piece of machinery, whether it's a tractor or a vehicle on the roadway, with his medical conditions, with his substance use, it's a ticking time bomb. I mean, we are certainly lucky that nobody was killed. He was nearly killed in this. From the reports, he was barely agonally breathing when the deputies arrived. They were able to get him the treatment that he needed. So having no license is kind of a blessing in our eyes as far as keeping him off the road. With that in mind, with his health conditions, I'm sure the jail isn't really jumping to want to have him in there. So I would leave it to the court's discretion on that. As far as 7411 probation, From what I can see on his CCH, it is accurate. He does not have any prior drug convictions, and I don't see that he has done a 7411 before. So we'd leave it to the court's discretion on that. Thank you.
Yeah, we all thought the same thing. His he reports he was using cocaine once or twice a month or every 2 months to help him kill the pain. He was consuming alcohol once or twice a week. He would drink 2 to 3 beers. The whole evidence belies all that. Your truck is like a cartoon of a guy that throws all his beer cans in the back. There's pints of schnapps and there's beer in there and there's beer cans, and you're drinking a lot of beer and perhaps alcohol. What made you hit those trees was not the cocaine, it was the fentanyl. And I don't have a good handle on where that came from. As you know, people are mixing fentanyl with all kinds of stuff. If I gave you a blood test right now and see what's in your system, what would show up?
Nothing that I know of.
All right, what did you take this day? You said you don't have a very good memory. What did you take that got you in that state where you were
I
barely
don't
breathing?
have any recollection of what happened that afternoon at all. I'm missing 2 or 3 days. I hardly remember the hospital.
Well, you remembered going to Walmart and
I
Lockport Liquor.
No, I never made it to Walmart. That was my plan.
Well, where were you? You were headed down M60. You don't live that way.
No, I don't.
Where were you coming from?
I really don't know. I don't remember.
Did you stop at the Eagles or something? That's out that way?
Not that I remember.
Priscilla, what's your thought here?
Your Honor, I don't have much to add as to from what is my report and what Ms. Davis and Mr. Tim George have added. But I do believe Mr. Hewitt is underreporting his use of alcohol and substance abuse. As we stated, there was multiple cans in the back of his truck, whether, he says he wasn't drinking that day, and it's proven he wasn't, but he's obviously operating a vehicle at some point in time, and while intoxicated. And like Ms. Davis said, he's just a ticking bomb he's really lucky that he survived this incident and he didn't hurt anyone else. I do believe a supervision is warranted in this case. So probation department can oversee that Mr. Hewitt is not consuming any substance or alcohol.
Well, I have to put him on probation for him to be eligible for 7411 probation. On a drug charge. In the old days, that used to carry a suspension of your license. That no longer does. Order 10 days jail, credit 2. The 10 days ordered. 8 are deferred. Ms. Davis is right, and your medical condition, they don't really want you in the jail. There's 0 fine. There's a $75 crime victims' rights fee, a $50 state minimum fee. I'm gonna waive the attorney fee, although he certainly earned it. And I'm gonna do a 12-month probation, and that's $480 oversight fee. Substance abuse counseling and treatment as directed, which may be prime for life, sign a release, no drugs, no alcohol. I want a test. In fact, I'd like to get a test today. I want to know what's in his bloodstream.
You can send them right to the day reporting center after this.
Yes. Are you prescribed pain medication?
Yes. I just had a tooth pulled a couple days ago, and they gave me, like 12 Norcos to take. Other than that, I'm only taking Tylenol and aspirin for pain, and gabapentin,
Gabapentin?
which is Neurontin.
Yes. What is the source of all this?
I had spinal cord surgery. They replaced C3 and C4 vertebrae in my neck by rebuilding it with cadaver bones. And then my spinal cord was cutting it, or my vertebrae were cutting into my spinal cord. And they said I was one bale of hay for being in a wheelchair. I didn't have any pain at the time. I was starting to lose feeling below my waist. And it wouldn't have been fair for my parents if I put myself in a wheelchair.
How old were you when all that happened?
About 50. I don't know when it happened. They don't either. They said it had been an ongoing thing.
Well, you were involved in all kinds of athletic endeavors.
It was an ongoing thing they said it could have been 20 years that it was happening, but it was happening slowly. Usually they have like a 3 to 6 month waiting list to get in to have spinal cord surgery with Dr. Fabi. They thought it was so serious that they had me in 18 hours.
The probation is going to be 7411 eligible. The OUIL charge, that there's no sense to put you on 2 probations. I'm going to give you, you're going to lose your license. That's punishment enough. Then you get 2 days credit, 2 days concurrent with the 7411. And no fine and cost in that case. Again, I don't know what you took. I don't know if you snorted some powdered cocaine, you smoked some crack that had fentanyl in it, whether you're taking fentanyl otherwise in a pill or liquid, or so I'm fumbling in the dark. But I want to know what's in your system right now. And we're going to find out what we're actually dealing with. Because if it is fentanyl, you can't just turn it off like a switch. All right, you go with Miss Walton. You're going to do a drug test at the day reporting center. We're going to find out what's in your system. If your prescribed Norcos are in there, that's not an issue. But I want to know what else is in there.
The only thing they had me on was amoxicillin, was an antibiotic, along with the Norcos when I had my tooth extracted.
Well, that shouldn't affect any. If you get back to
Okay.
Mr. George, and you go with Miss Walton. Thank you,
Your Honor.
Thank you, Your Honor.
Thank you.
All right, Ms. Davis, you're off the hook now.
Yes, we're
Ms. Gishwin's
done.
got her 10 o'clock scholar.
Alrighty, friends, second session on a Wednesday. Good to have you here with me this afternoon. Let's go to Fulton County, Georgia, and we'll spend a few minutes with Judge McAfee as he does a bond hearing.
We ready?
Yes, Your Honor.
All right, we'll go on the record on position number 3, indictment number 26 SC 002916, John Allen Pearson Jr. Are you Mr. Pearson Jr.? Sorry. All right. Counsel, what are we here for today?
It's a bond hearing, Your Honor.
All right.
And Judge, Mr. Pearson is 44 years old. He's been a nearly lifelong resident of Georgia. He's been here since he was 16. He was born in Germany. His father was in the military, but he has lived in Georgia for quite a while. He lives in 2009 Wells Drive, so he has a solid address. Has 3 children, 2 of which are minors that are in Georgia, and 1 who is an adult. So he has significant connections to the community, Your Honor. He's a high school graduate, so he's educated. He has training in HVAC as well, so he has work opportunities. He was actually working at Soap City Car Wash at the time of his arrest. That job is still open for him. He's been working there for 7 years. So he has a reliable work history as well. He is on probation in Fulton County. And in fact, I think he has a revocation hearing coming up next week with Judge Cox. So, you know, us getting a bond today doesn't mean that necessarily he will get out immediately. However, we're having this hearing in anticipation of something happening on his probation revocation that will lift the hold, and then he will be allowed to post a bond, a reduced bond here. He has a criminal history. I think that the most recent one is the case that he's on probation for here. I think that he's somewhere in the ballpark of three or four prior felony convictions, but I'll let the state elucidate the court on that a little in a little more detail, since I don't have a GCIC yet. He has had some medical issues at the jail. He suffers from seizures. It's unclear what exactly is causing them, which is cause for concern. So I think he needs to figure that out. And the medical care at the jail, unfortunately, is insufficient to diagnose the problem correctly. He has had some mental health difficulties as well, as far as he's been diagnosed with ADHD and bipolar schizophrenia. And from what I understand, he's not being medicated for that at the jail either. So there are issues there. As far as the case is concerned, Judge, Ms. Foster and I have been discussing it vigorously this morning. And we have some disagreements about what the evidence shows. What the weight of it is, as far as the bond factors are concerned, is, in my eyes, very minimal. Police respond to a 911 call of somebody hitting a woman with a gun. They respond, and there are 3 individuals outside of an apartment that refuse to identify themselves. There's no names in the reports or in the warrants. I've heard a 911 call from someone named Nate. I don't have a last name. Apparently, Ms. Foster spoke to Nate this morning. He didn't give her his last name either. Nate says he has a video. That video is not on Axon, apparently. They make entry into the apartment after yelling outside the door for a few minutes. When they make entry to the apartment, they find Mr. Pearson asleep inside the apartment. They rouse him, detain him. They start going through the rooms. They find the victim asleep in a different room. They rouse her, and she says, "What's going on? Why are you here?" They ask her, "Are you okay?" She goes, "I'm fine." What's wrong? And they say, what were you doing? And she says, and she's visibly intoxicated, she says, "We were partying, we were drinking." At that point, when she gets out of the room and she sees that Mr. Pearson is detained by police, she starts attacking police and physically resisting them. say, let him go. They ask her about, she has a cut on her nose. They ask her about how did that occur? And she goes, I don't even remember. We were partying, we were drinking. But I have never quite seen a victim physically resist the arrest of a defendant before. I've seen victims that even on the scene are reticent or potentially say, oh, no, he didn't do it, don't arrest him. But physical resistance is quite a league away from that even. So at this point, Judge, we're asking for a reasonable bond, one that takes into account that Mr. Pearson is not a man of means, takes into account the weight of the evidence, which at this point seems that there's a lot of contradictory pieces of evidence in this case that I very much look forward to exploring. So I think that considering all of that, a bond is appropriate despite his criminal history, despite him being on probation. And we would ask something in the ballpark of $5,000 in the aggregate, Judge.
All right. Ms. Foster?
Yes, Your Honor. I will first ask that the state would like a no bond for Mr. Pearson. As Mr. Attorney Farmer stated, Mr. Pearson was convicted back in July 15th of 2025 for strangling the victim in this case that we have before us now. Additionally, he was arrested back in October 2025 for a battery misdemeanor in state court for additionally harming the victim in this case. In the 2025 SC case, he has a specific no contact with the victim that's listed in our case before us. Additionally, I'm looking at the bond that he received in the misdemeanor state court case, which also lists no contact with the victim, again, it listed in our case. So going off the Iola factors, the state will argue that while the victim is a victim of domestic violence herself, we believe that he is a risk of intimidating that witness and our victim in this case. We believe that he is a danger to the community based on the charges that he had before us, being ag assault that he pled to in 2025, a battery open case in 2025, and a new ag assault case where he also possessed a firearm. Lastly, we will say that he is at risk of committing a new felony. As Attorney Salmon stated, he pled to forgery in the first degree in 2008 in Clayton County, a theft by taking in Fulton County in 2010, possession of marijuana in Fulton County in 2011, and then, as I stated before, that aggravated assault against the same victim in our case back in last year in 2025. So we ask that he be denied bond based on those factors alone. He does have a probation revocation coming up in Cox, but we just believe that we don't want him to try to contact or interact with the victim again. He is only getting worse. He literally pistol whipped her. The video shows that he was in the same home as her. So again, he violated the bond order and the no contact order in that 25 SC case. But that's all from the state.
All right. Well, it seems like there's a genuine dispute of facts, and Mr. Pearson, I think you'll have an opportunity to prove that your version may be true. But given that you were on felony probation at the time and you were, found in possession of a firearm, contacting the victim that you had a no contact provision with, I'm going to deny bond at this time for those reasons.
Alrighty, friends, it is second session on a beautiful Wednesday. My name is Dan. It is good to have you here with me. Let's change things up. Let's go to a happy place, and we'll pull up Judge Wolfe for you as he does an adoption.
Hi, good morning. We'll start with the call of the docket. So call the first case.
The matter of Carson Ann Moore and Cash Douglas Moore.
Secretary, my fault.
Judge,
Good morning.
quite a happy occasion.
Glad to have a happy occasion.
So we're here for a step parent adoption.
All
Are
right.
you ready, Judge? And is it
Ready,
okay if we
you are.
proceed with termination?
Everyone who's going to testify, if you'll raise your right hand, let's place you on the oath.
Do you all solemnly swear or affirm the testimony you're about to give is the truth, whole truth, nothing but the truth, so help you God?
All right.
So I'll start with the termination first. So state your name for the court.
Caitlin Dupree,
And what is your relationship to the children?
mother.
And would you provide information for the court? Has the biological father provided any financial support for these children?
Only one court-ordered payment to avoid incarceration.
Just- There you go. I was going to ask you to step over so that you're picked up by the microphone.
Do I need to repeat that?
That's fine. Go ahead.
Okay, only one court-ordered payment to avoid incarceration.
And has he maintained regular contact with the children?
No.
Excuse me for interrupting. How long ago was that one payment?
April,
Which is court ordered, is that right?
correct, in Indiana.
And are you aware that failure to support or visit the children without justifiable cause can lead to?
Yes.
And did our office provide an opportunity for him to sign consent for adoption?
Yes.
And can you describe the relationship between the stepfather and the children?
Since he entered their lives 6 years ago, he has been the father that they needed. So he has stepped up and done everything they needed as dad.
And did we ensure that biological father was served with the petition?
Yes.
We had successful service. He's not tried to contact my office or you?
No.
And you've provided the court with all the necessary documentation?
Yes, ma'am.
So you're asking this honorable judge to approve termination?
Yes.
All right.
Can I proceed now?
You may.
Next step. All right, have a few questions for stepfather.
Yes, ma'am.
Can you state your name for the judge, please?
Justin Dupree.
And how long have you been in the children's lives?
They stepped into my life about 6 years ago after Caitlin and I got married. So 6 years, sir.
Do you feel like you have a bond with these children?
Absolutely. They're my children.
6 years ago, is that when you came in?
Yes, sir.
And how do you plan to provide for these children to include their emotional, psychological, and financial needs?
Best ability is availability. I haven't missed a day. The only day I've missed is for deployments. So that's it.
So you're active duty?
Yes, ma'am.
Thank you. And how would you ensure stability and continuity in their lives if the judge orders this adoption?
Nothing would change if this adoption is granted. Same school, same home. We have them 24/7. So stability is no question.
And are you aware that if you and your wife were to divorce, that you would be responsible for child support?
Absolutely. I would gladly accept that responsibility.
And if you were to pass away, these children would inherit of your estate as if they were born of you.
That's perfectly fine, ma'am.
I assume it's not perfectly common that you would pass away, but you're saying it is. Now, let me make sure I'm understanding. We've got two younger children. Those are yours and Mrs. Dupree's they're your biological children.
Yes, sir.
And
But
then
these
the
aren't
two
the,
that you're adopting that are standing behind you are, there we go. Step right up there so we can get a good look at them. All right.
So these are the two.
All right.
So, Mom, do you agree to have him adopt your children?
Yes, absolutely.
Who's Carson? All right, Carson, you okay with this adoption? You understand what we're doing today? This man's going to be your father in every way, shape, form, and fashion. I know he probably already is in every other way, but you understand he's going to be dad from now on.
Yes.
And your Cash, you named after Johnny Cash? Is that where that came from? No, good. You understand what we're doing as well, and you understand that you're agreeable to this adoption as well. Is that correct? Did I cut you off from anything else?
No, my pleasure.
Mr. and Ms. Dupree, one of the things that I love to do in this job is to grant adoptions where the situation is appropriate, and in this case, it clearly is. I would simply point out to you that you are assuming a different role, and this Juan has touched on that. But after today, the relationship you have with the children may not change in your day-to-day activities, but legally it will change, and you will no longer be their stepfather. You're going to be their father in every way, shape, form, and fashion, both in the relationship you already have with them, as well as in the legal technological jargon that we all follow. And the legal classification will be you're their father. The same as if there'll be a new birth certificate issued and that you will be shown as their father. So I know that, let's see, I think it's Carson is 15. Let's see, you were born in 2015, so you're 11, right? I have a granddaughter that just is about to turn 11. Sooner or later, Carson's going to be a teenager. You understand what that entails?
Yes, sir.
You have you read up on it, studied on it, and understand what it's going to be like to have a couple of teenagers under your roof and that you're going to be responsible for.
I look forward to the.
All right, well, talk to me in about 5 years, and we'll see how much you look forward to. This is no respect about you, but having raised a bunch of teenagers, I can tell you, it can be challenging at times when you get those late night phone calls and things. But the main thing I want you to understand is that if something happens, let's say Carson starts dating some guy that you don't approve of and she won't listen to you, you cannot bring her back to me and tell me you've made a terrible mistake in adopting her. You understand that, right? She's going to be yours from now on.
Yes, sir.
Right?
Understood.
Same thing with Cash. He wrecks your car the first time and you can't bring him back to me and say, hey, I want to do over it. So both of you all understand that. All right. Well, I'm of the opinion that the proof has been by clear and convincing evidence that the defendant has abandoned the minor children under the statutory guidelines and failing to support other than nominal support and failing to visit with the minor children for a period in excess of 4 months prior to the filing of this petition. And the court is of the opinion that it is in the best interest of the minor children by clear and convincing evidence that the termination of parental rights occur. The court further finds it is in the best interest of the minor children that the adoption take place. And I'm happy to grant your adoption. So,
Thank you, sir.
you have an order.
We've already turned one in, and I did have 2 witnesses in case you needed them.
Bring on and have me testify.
Thanks, sir.
Do you have that order? Or do we need?
I don't have the order, so.
And so our first witness, would you state your name, please?
Kim Wentworth,
And your relationship to these parties?
my daughter and son-in-law, and grandma.
Do you feel like this adoption is in the best interest of the children?
Absolutely,
And the statements they made to the court were truthful and accurate?
absolutely.
Thank you. State your name, please.
Michael Estrada,
And your relationship?
very close friend.
Were the statements that they both made to the judge, were those truthful and accurate?
Yes,
And you feel like this is in the best interest of these children?
yes.
And Judge, they would love to have a picture with you,
I'm sorry.
a photo with you.
Sure. Do they want to come up here where they can have the picture made? Y'all want to come on up here? Come on.
Where's that, sir?
Carson, you want to have a seat in the big chair so you can be the.
Cash,
Cash, you want to have a seat in the big chair? Come on. Don't be shy. Have a seat. All right. We're going to put you up.
Yes, go ahead.
Cash, you got to hold over.
The little one want to face forward. Look at the phone.
Look at the phone.
We'll take a look at. Perfect. Thank you, Judge.
Congratulations. Hey, you do a souvenir for them. So, there you go. Cash. You know, there's one for each. Your own individual together. Thanks, sir. All right. Thank you.
Thank you.
Congratulations. Thank you, sir.
So there you are, friends. A good moment. Not everything that happens in court is a downer, though quite often it is. And unfortunately, now that we had that feel-good moment, I need to snap you back to reality. We're going to go to Judge Aquilina, and she is dealing with a bond violation, specifically a contact that was not supposed to happen. So we're going to take a look at that. Warning as we go into this, the first 10 or 15 seconds are muted. Just stick with it. The audio will come in.
May 29th, 2026, that you had direct contact with Chelsea Cannon, and she is the victim in the pending matter where there is count 2, aggravated domestic violence, punishable by 1 year, count 3, assault with intent to great bodily harm less than murder or by strangulation, a felony punishable by 10 years. There's the habitual offender second offense notice, which means that on the primary offense, which would be the tenure, that would be subject to up to 15 years. And these are allegations. You have all your rights intact. However, there was a no contact order, and it's being alleged that you had contact with her in violation of Public Act 53. So therefore, we are at an evidentiary hearing, and you have had an opportunity to talk about all that with your attorney?
Yes, I
And you
do.
remain satisfied with him?
Yes, I do.
Have you consumed any alcohol, marijuana, taken any medication that would alter you in any way?
No.
And is there medication you're supposed to be on that you're not on?
No.
Any sign of fever, COVID, or other illness? And are both counsel ready to proceed with a brief evidentiary hearing?
Your Honor, the people are ready to proceed. However, after talking to the defense, it is my understanding that they wish to plead guilty as the officer is present.
Is that correct?
That's correct, Your Honor.
All right. And sir, did anyone force, threaten, or coerce you to plead?
No, Your Honor.
Anyone promise you anything cause you to plead?
No, Your Honor.
And you've discussed various options with your attorney. The officer is ready to go into a full hearing, and you've decided along with your attorney the best thing for you to do is to plead?
Yes, sir.
All right. And sir, as to having direct contact with Chelsea Shannon, and let me just be more clear, that would have been
on May 24th at 11:46.
Thank you. May 24th, 2026,
Yes,
and I'm amending the bench warrant to reflect that. Any objection by counsel?
No, Your Honor.
All right. So as to having direct contact with Chelsea Shannon, May 24th, 2026, in violation of Public Act 53, how do you plead?
Guilty, Your Honor.
And sir, you understood those were the terms and conditions of your bond?
Understood, yes, sir.
And you intentionally had, this was not accidental, you intentionally had contact with her and ended up having a fight with her where law enforcement was called. Is all of that correct?
To a certain extent.
Okay, well, let's regard, I mean,
Yeah.
it was reported
I
that there was.
did have contact. I wouldn't say I was fighting, but I did have contact.
All right, well, it was reported there was a fight, regardless of whether or not there was a fight. That's really not an issue here. The issue is you had contact with her and law enforcement was called. Is that correct?
Yes, sir.
Both of those things are correct.
Yes, sir.
All right. Okay. Are there new charges stemming from this?
There are not, Your Honor.
Okay, all right, thank you. Court finds by preponderance of the evidence that defendant had contact with the protected person, Chelsea Shannon. He has acknowledged of his own free will that he pled guilty. No one forced him, threatened him. They knew there was a no contact order, and he ended up being in contact with her in a situation where then law enforcement was called, and it was verified that he should not have been in contact with her because of Public Act 53. You're going to sentence them?
Please, Your Honor.
What is the recommendation on behalf of probation, or on behalf of people?
Yes, Your Honor. The people are very, very concerned, as this is Mr. Krosky's second PA 53 violation. The first being in district court back in December of last year, Your Honor. And with this being May 24th, that was 5 months that he, that was 5 months where he had 2 different violations, Your Honor. The people are concerned that if Mr. Krosky is left of his own devices, it's going to endanger Miss Shannon. The police report in this case ultimately says, Your Honor, that both of them are essentially fighting in the street, intoxicated. So the people are concerned, Your Honor, that Mr. Krosky is consuming alcohol while on bond, as well as potentially having contact with the victim in this case, Your Honor. I do believe that there should be some kind of bond in this case. I would ask for a 10,000 cash surety bond, Your Honor. Given Mr. Krosky now having a second violation, Ms. Shannon needs to be protected, Your Honor, and I think that's the best way to do that at this time. Thank you.
Counsel?
Thank you, Your Honor. Respectfully, I request that Your Honor just allow Mr. Krosky to remain out on his current bond. He was just able to get out a few days ago, Your Honor, because separately from this, he served 8 days on the tether violation. Your Honor, that was unrelated directly to this, but he was able to get back out, Your Honor. He's back on tether. The tether seems to be operating fine now, Your Honor. Mr. Krosky is in a very, very difficult situation right now in his life currently. He has an excellent job as a manager, which he's at risk of losing due to these allegations and the tribulations of what he's been through in the past 5 months, Your Honor. In my interactions with him, he's always been very cordial. He's very communicative. He's been reporting into pretrial services. He did serve some time in between from when he posted his interim bond on this file, albeit it was more directly related to the tether, Your Honor. But still, he's back out now. He has a lot of financial obligations. He's been trying to take care of his kids, Your Honor. He has a lot of financial obligations related to his children. And Your Honor, to the best of my knowledge, he has a little bit of an experience with the criminal justice system, but it isn't too bad. When we're negotiating plea deals here and looking at his guidelines, Your Honor, from what I recall, his guideline scores are pretty low, actually, given the charges and everything else. But he's not a flight risk, Your Honor. He has a stable place to stay. He has support with him here today. He has connections to the community. And Your Honor, he's just had some personal struggles since he's been out on bond, but he's in a desperate financial situation. He needs to hang on to his job, Your Honor. And if he ends up back in jail again, he's immediately going to lose that, most likely. So, Your Honor, he's learned a very powerful lesson here. He's very sorry for his actions. He knows he shouldn't have been over there. He knows he shouldn't have had contact with her. And he's got to make sure this never happens again, Your Honor. So respectfully, just based on the circumstances in their totality, I just request that Your Honor consider giving Mr. Krosky one last chance here. Certainly he's going to prove it to Your Honor if he's given that opportunity. And I'll make sure that he complies with all Your Honor's conditions. Thank you.
Do we have a final pretrial already?
We did, Your Honor. That was on June 24th.
That's what I have here, just making sure it's in get moved. And then when is the trial?
Trial is currently set, Your Honor, on August 21st.
Thank you. Sir, what would you like me to know?
Since that incident, you looked me straight in my face and told me I could either cook at prison or I could cook at Applebee's. You said, don't do it again. Don't go see her. Anytime I think about doing something stupid, your face pops up in my head. And
It's probably a good thing.
It's a very good thing. I got a lot going on, and that's the last thing on my mind. I'm not in danger to anybody.
What's your relationship to Ms. Shannon? Were you dating? Do you have kids in common?
We were dating for over like a year and a half, almost 2 years, 2-3 years.
Do you have a
living with each
child with
other.
her?
No, we don't.
Does she have your possessions?
She at some things she had, not anymore.
Like,
Not
okay,
anymore.
so there's nothing between you, no possessions, no children, nothing.
Nothing to talk about at all. We have no conversations.
So why were you with her?
That I can't explain. She called me, kept calling me and calling me and calling me, and I folded. I was done.
I don't care if she dances naked around your car or in front of your bedroom windows. You call 911, you get out of there. You don't answer the door. You don't open your car door and say, get in. You do nothing. There's a lot of other women in the world. You got a woman here with you? Is that a friend or is that you're dating her?
I'm dating her.
How long have you been dating?
We have been off and on for over 10 years. And yeah.
Okay, so you're disrespecting this woman who's come to court to support you by being with Ms. Shannon.
No, we're not.
No?
I mean,
I'd be mad if I were dating you and you went to see your ex.
we weren't dating at the time when that incident happened. You told me find a nice girl, leave that girl alone and this and that, and I've listened. I left her alone. I talked to her. She's my support. She helps me through a lot.
So this is the old story of we were on a break, so it doesn't count kind of thing. I got this. Tell me about the alcohol. Do I need to have an alcohol spray tether on you?
No, ma'am.
Why were you consuming alcohol?
At that point in time, I was just lost.
So alcohol finds you, you found in the bottom of an alcohol bottle? You like, I Dream of Jeannie, it's an old show, you remember that show? You ever watch it?
That show. Yes, sir. I know.
Okay, so you poured yourself into that bottle and then you came out and saw your ex. Was that the story you're telling me today, pretty much? Mm-hmm.
Yes and no.
You see how ridiculous it sounds, sir? You're being ridiculous. You're smarter than that.
And when I sat down and you told me that, that's what opened my, like, what am I doing with my life? And that's ever since we got tried and you wrote that last bond and said, don't do it again. I've been really holding that to court, been trying to get everything together. I even got trying to get into the Reconnect program.
You need to get in there.
They advised me to wait till my case was over because it would be silly to start my case. I talked to somebody and I told them about trial and I was open. They advised me to do it after the trial, so.
Okay, and given this, you still don't want the plea offer.
What was my plea offer again? Or the one count of domestic, only the second count?
It was, you would, your guidelines would be 0 to 17 with a county cap, meaning I could sentence you anywhere from 0 to 365 days. You would plead to count 2, aggravated domestic violence, which is a year misdemeanor, and then felonious assault, which is a 4-year felony. And what would get dismissed is count 3, which is the 10-year felony assault with intent to grave bodily harm less than murder or by strangulation. And the habitual, which takes the 10-year to 15 years, would also be dismissed. I don't know what happened here. I'm just asking, but I don't know if people are even willing to open it. But here's what I see. On your rights remain intact. Just want to give you a little window. You got history with this woman. Twice you've been in her presence. Police have been called. That's just what I know about. I don't know your history. I don't know if they're filing an other acts kind of motion. But you've been in front of her, or you've been with her a number of times where law enforcement has been called. Law enforcement can testify as to this history between the two of you. And I don't know what your defense is here, but it looks like there's a history here that kind of weighs more heavily in the people's side of the things. I don't know, maybe you have a great defense here and that's what you're holding out for. So, you still wish to not plead?
I'm not taking the plea.
Okay, all right. And you're on that GPS tower?
Yes, sure.
Mhm. And you posted the 20,000 cash surety?
I posted both funds.
All right. Where do you work?
When or where?
When you work at Applebee's?
Yeah, well, the past 2 days was my 2 days off, so the rest of the week.
So are you, what, is there a shift or how does it?
I work night shifts. I work nights, 3 to we close at 12, so I'm out of there on a good day, probably by 12:45, 1 o'clock.
How often are you consuming alcohol?
Very seldom. I haven't drank in probably the last 3 months. But there was a point in time where I did have a bottle, crying at night, just doing. That's.
All right, well, trials around the window or around the door and, you know, I don't know, I'm gonna shut all the windows if there's another violation. I should do it now. I should just toss your light and give the county the bond money. I'm not gonna do that because you need some time to prepare with your counsel. However, I'm gonna let the bond order stand that I did February 23rd, 2026. With the jail GPS tether, you're not to be within 1,500 feet of the victim. I don't care what the excuse is. If you decide to be with her, you're gonna lose your bond money. You're gonna be in jail. I'm gonna consider this if you're found guilty by the jury. And like I said, you can cook in prison because your guidelines, it appears, are 0 to 21. And I can go over that. And with this history, along with what I might hear at trial, I could easily put you in for 2 or 3 years. By then, this girlfriend who's here, she's gonna get tired, she's gonna find another man, one who's present without a criminal history, who doesn't beat up women. Are we clear?
Yes, we are.
You had better be the nicest, kindest, most productive person in our city. If not, I've got jail beds and prison beds that I will keep open for you, courtesy of the sheriff and the warden. Have I been clear?
1,000%.
Women that you date deserve roses, not bruises. This court deserves the respect of you following my orders. If you do not do that, there will be no other arguments, counsel. Don't even try it because I will sanction you for wasting my time. Because although your client has to do the work, if you just want to listen to you, I'm not going to listen to you either. I'm simply going to tell him, I told you, I'm going to have my court reporter hand him this record and say, we're done.
Understood, Your Honor.
I understand, Your Honor.
And, oh, I won't interfere with your rights. We can have a hearing. But it looks to me like the police have your number. They know who you are. They're going to respond, arrest, and they're going to say, Aquilina said, we're keeping it this time. Anything I haven't been clear about?
Nothing. I hear everything you're saying. I hear it.
See, I deal with evidence, so I want to see the appropriate actions. Because otherwise, say goodbye to everybody, because you're going away. The contempt carries with 93 days. We'll start there, and then we'll see what happens in front of the jury. I will consider all the violations as I can.
I understand.
Because you would be a really poor candidate for probation. Always worry, sir. That's all for the record. Thank you.
Thank you, Your Honor.
Alrighty, friends. One more for today's second session. We're going to go to Judge McNally. He has a pair of defendants who were racing each other over 100 miles an hour in a 35-mile-an-hour zone. So let's see how this goes over.
Noaman Mr. Al-Jalem, and Mr. Sala, and let's call in Mr. Caleb. People against Wasim Marzoug Al-Jalem, 26F246492. And I also have Noaman Salah, 26F246497. Okay, so I want Mr. Cayley in here, John.
He's not answering. Hey, Judge McGinty, Judge McGinty.
Mr. Newman, your appearance.
Hello, Your Honor. I'm here. Attorney David Newman for Noaman Salah. Is he present via Zoom? Mr. Salah, please state your name for the record.
My name is Noaman Salah.
So now we got to bring in Mr. Al-Jalem and Mr. Dabolsky.
I'm trying to bring them out of the breakout room, Judge. They're still in there.
Okay.
I may just have to close them.
Here you go.
I'm just going to join it real quick and tell them to return.
So I got Mr. Sala and Mr. Newman out here, but we're pulling up, getting Mr. Dabolsky and Mr. Al-Jalem out of the breakout room. Mr. Dabolsky, your appearance?
Good morning, Your Honor. For the record, Tim Dabolsky appearing on behalf of the defendant who is to my left. Would you please state your name?
Wasim Marzouk Al-Jalem.
And you consent to this matter being broadcast over Zoom, correct?
Copy.
Thank you, Judge.
Mr. Cayley, your name? So, Mr. Newman, I didn't know what was going on. I didn't realize there were co-defendants. I called in Mr. Dabolsky. He and I went into chambers with Mr. Cayley.
Right.
I explained to them, this is so inappropriate what these two allegedly did. I'm not real happy with this plea being reduced from reckless to drag race. I'm not the prosecutor, though. But I did tell both he and Mr. Dabolsky, and I'm telling you, and I'm telling your clients, that this is way too nice for me. I'm not the prosecutor. It is extremely rare when I stand there and start saying, I feel like it's overstepping the bounds for a judge to start questioning every plea agreement. Mr. Cayley will tell you I don't do that. I think any other prosecutor, it's not my province. But I just want these guys to know. I want them to know how ridiculous that the allegation is. So I'm not going to get in the middle. I'm going to take this plea to drag racing. I think they should lose their license. I'm not the Secretary of State. I'm not in the legislature. I'm going to take their plea as offered to reckless driving, which is 4 points, I believe, 90 days jail. Costs are all of those and $100 fine, I believe. Am I correct on that? I haven't had a drag racing in quite a while. Yeah, I'm sorry. I misspoke. I'll dismiss the reckless. But we're going to talk. So, Mr. Newman, I wanted to disclose that conversation to you because I didn't realize at the time that I called in Mr. Dabolsky that these guys were how do I say it? They weren't co-defendants, but that they were both engaging in this type of behavior. So I want you to hear that, and I want Mr. Salah to hear that. Okay?
Thank you. Thank you, Your Honor.
Yes, sir. Thank you.
And you said and Mr. Cayley did tell me he spoke to the officer who was fine with this. He approved of this plea agreement, right, Mr. Cayley?
Yes.
And you also mentioned that Mr. Salah had done some kind of a class. What class did he do?
Your Honor, he did take an online driving class. It was more inclined towards him managing his speed and also towards him being more careful on the road.
So what do you want me to order? I guess you mentioned that you thought I should order a class.
Correct.
What class do you want me to order?
Product safety improvement class.
Okay. So I'm going to go ahead and do this. I'm going to take the plea and I'm going to sentence him today. So, gentlemen, can I see your client, Mr. Dabolsky? If Mr. Sala and Mr.
Yes, sir.
El Jalam, if you plead guilty to drag racing, this is punishable by up to $100 fines, 90 days jail, costs are all those, 4 points. And I'm just telling you, I'm not likely to go easy on this one. Do you understand what I said, Mr. Sala?
Yes, sir.
Do you understand what I just said, Mr. El Jalam?
Yes, sir. I understand.
If you do that, I'll dismiss the reckless driving, but there's going to be some consequences. Do you understand what I said, Mr. Sala?
Yes, sir. Yes,
Do you
sir.
understand what I said, Mr. El Jalam?
Yes, Judge.
You have the right to a trial here. At a trial, you have the right to remain silent. You do not have to say anything. If you say something in or out of court, whether orally or in writing, it can be used against you. At a trial, you are presumed to be innocent, and they have to prove you guilty beyond a reasonable doubt. By pleading guilty to drag racing, you're waiving your right to a trial on the reckless charge or any reduced charge, and we will not have a trial, and you'll be giving up your constitutional right to a jury trial. Do you understand that, Mr. Sala?
Yes, sir.
Mr.
Yes,
El
Judge.
Jalam?
Yes, sir.
And you understand that you're waiving the right to cross-examine prosecution witnesses, to bring in your own, to use the subpoena powers of the court to bring in those witnesses. If you plead guilty, you're giving up all those rights, and we will not have a trial of any kind. Do you understand that, Mr. Sala?
Yes, sir.
Mr. El Jalam?
Yes, Judge. I understand.
All right, to the charge of drag racing. How do you plead, Mr. Sala?
Guilty.
The charge of drag racing. How do you plead, Mr. El Jalam?
I'll plead guilty, Judge.
Were you at 2:25 in the morning, Mr. Sala, operating a motor vehicle on Will Carlton Road near John L. in the city of Flat Rock, County of Wayne?
Yes.
You said yes?
Yes, yeah.
And were you operating that motor vehicle traveling 110 miles an hour in a 35 mile per hour speed zone?
Yes, Your Honor.
And that was at 2:25 in the morning on the 13th of June of 26, true?
Yes, Your Honor.
Mr. El Jalam, the charge of drag racing again, how do you plead?
Guilty.
Were you operating a motor vehicle on the 13th of June of 26 at 2:33 in the morning on Will Carlton near John L. and Flat Rock?
Yes, sir. I was.
And were you traveling 110 in a 35 mile per hour zone?
Yes, sir. I was.
Are you on probation or parole, Mr. El Jalam?
No, I am not.
Are you Mr. Sala? Are you on
No,
probation?
No, Your Honor.
I'm sorry. You're not on probation or parole?
No.
Anybody force you to plead guilty, Mr. El Jalam?
No, nobody forced me to do anything.
Mr. Sala?
No, Your Honor.
All right. I'm going to accept your guilty, please. Do you want to say anything? Accept your guilty, please, excuse me, to drag racing. Dismiss the original charge of reckless. Do you want to say anything? I'm ready for sentencing now, guys, if you are.
We're ready, Your Honor.
We're
Do you
also
wanna
ready,
say-
Your Honor.
Do you want to say anything regarding sentencing, Mr. Cayley?
No, Your Honor, I think you made it quite clear that I understand the gravity of the offense, and I hope these guys do too.
Well, they're going to when I'm done. Mr. Newman or Mr. Davolsky, I don't care who starts, gentlemen, but one of you can allocute for your client.
Judge, I'll allocate first if you don't mind.
Sure.
Before the court, my client's 23 years old. He has 24 years old. He has a clean criminal record. He understands and wishes he could relive this event. He understands that he's lucky that he didn't get into an accident. No one got hurt. He understands that his behavior was reckless. There's no excuse in the world for driving 110 and 35 miles an hour. And that comes out of my client's mouth. I mean, he knows that he's up against a serious situation here, and he would hope that the court would take his full record into consideration when imposing penalty. Thank you, Your Honor.
Thank you. Mr. Newman?
Your Honor, if I may, my client, Mr. Sala, he's explained to me how stupid his behavior was in the situation, Your Honor. He's told me that he definitely was not thinking at the time. He's 26 years old, Your Honor. He has one child. He has another child on the way. He has a wife that's currently living in the state of Michigan that he has to tend to. He understands that he's not a kid. That this matter right now has truly opened his eyes to the simple fact that it's not about him. That there's others that he has to think about, and that this is one of those situations where it's not going to happen again. He's told me he's terribly sorry. He's sorry for the court. He's sorry for whatever he's put everybody through. This is one of those situations, Your Honor, where Mr. Sala would like to also say a couple words of apology of him apologizing to the court as to his actions. Mr. Sala, at this time, can you say a couple words, please?
Yes, I apologize for what I did, and I'll take full responsibility, and I'm willing to do whatever I can to fix. So, take classes, whether state classes. I just want to get
Wait,
my
you kind of
license
cut
because
out
I
there.
still have to go.
Wait. You kind of cut out there for a second. I heard your first part, and then you said, I'm willing to take responsibility or something like that. You kind of cut out. Can you repeat what you were saying?
I basically said like I take full responsibility, and I'm willing to do like classes or whatever I have to do to fix the situation. But I just didn't want my license getting suspended because I still got to go to my job and take care of my family and stuff like that.
Thank you, Mr. Sala.
Jeez. I'd love.
Yes.
Mr. Al-Jalal, do you have anything you'd like to say?
Yes, Judge, I am very sorry with the mistakes that I made that night. I know one little mistake could have ended my life, let alone another life. Anybody crossing the street. I just want you to know that I am very deeply sorry. And also, I am going to school for truck driving at the moment. I'm then like.
Say that again. You're going to school for what?
Truck driving, like CDL.
Okay.
I'm like about like a week and a half, almost 2 weeks done from being finished. So like in this like time of life is like probably like the worst thing that can happen. So like again, I'm very genuinely sorry about everything that happened.
Well, I'll tell you guys something. You cannot do this, Mr. Salam. You cannot do this, Mr. Al-Jalal. I mean, this is the equivalent, as far as I'm concerned, when you are driving 75 miles over the speed limit in a 35 mile per hour zone. It's the equivalent, as far as I'm concerned, of driving about 180 on I-75. This is ridiculous. I don't know how your lawyers did this. They did a great job for you guys. And I will add that both of you sound remorseful, which is important to me. But you're going to kill somebody driving like a maniac like that, and I mean it. Or yourself. And you have a kid, Mr. Sala?
Yes, Your Honor.
Well, you don't want to leave him without a father, right?
Yeah, that job, because that job used to give up, just my foot was heavy, but we got fired from that job. So, well, I'm not, and currently I'm not driving, so I'll just take a 4-month break.
You did the driver improvement course. Here's what I'm doing. I'll at least am pleased to hear that you two sound remorseful. But you just cannot do this. This is so incredibly dangerous. 12 months probation, both of you. Mr. Cayley's told me here that you did the online, or your lawyer said that. Mr. Cayley acknowledged that. Mr. Sala, and you did it awaiting the pretrial. 12 months probation. You two cannot leave the state without the consent of the court. You cannot violate any law or ordinance. If you change your address, place of employment, or home telephone number, you must notify probation. You have to report as directed. Mr. El-Jalam, you're to take a driver improvement course. Driver improvement course. Both of you are to serve 5 days on the court work program and pay $35 a day for that, for a total of $175. And each of you are to do 2 days of community service, and that here is to be completed in this case. I'll give you until December the 1st. You're both to pay fines of $100, costs $125. $75 victims' rights fee, $50 justice assessment. So fines and costs are $350. Probation fees are $240 for 590. Court work program fees are $175 for a total of $765. You may be eligible for early discharge. No violations. You get everything done. 6 months from now, you can, by statute, apply for early discharge. If you violate, you could get 90 days in jail. You have 21 days to appeal. You have 14 days to apply for a court-appointed lawyer for purposes of appeal. I'm at least glad to hear that you guys sound remorseful, it sounds like to me, and that means a lot to me. But this is nothing short of ignorant. No more of this nonsense. All right, counsel. Mr. Dabolsky, Mr. Newman, tell me when your clients can pay these.
Your Honor, if I may, my client, Mr. Sala, he's currently living in Kentucky at the time.
For how long?
My client said he'll be able to pay today online.
Okay.
Right.
And then he's going to meet with probation. So have him call the probation department. Or why don't you do that for him, Mr. Dabolsky? It's 734-671-0201. Actually, I think they can instruct him set up the court work program now.
Okay.
But all right. So why don't you have your client stay? We'll put him in a breakout room, Heather. Your client's coming back to do the court work program. I don't mind if he stays in Kentucky for a while, but how long is he supposed to work in Kentucky?
Your Honor, I'm supposed to be here for about 3 to 4 months, just until I pay everything off.
I'll say this, can reside in Kentucky until November the 5th. Court work program to be scheduled for Mr. Sala after that.
Sounds good.
So you're going to have to come back here by November the 5th, and we'll reschedule your schedule your court work program days.
Thank you,
Can
Your
your
Honor.
client
Thank
pay
you, Your
all
Honor.
this, Mr. Newman?
Yes, Your Honor.
So you can both pay it now. You can both stay online. We'll get probation to come on so you don't have to fool with that, Mr. Dabolsky. Gentlemen, go ahead.
Sorry, can I get till Monday, if you don't mind?
I'm sorry, I'm having a hard time hearing him, Mr. Noaman.
Can I get until Monday, think?
Until Monday?
Yeah.
Yeah, I don't have a problem. You paid I'll just make it November the 12th, okay?
Sounds good.
I mean, I'm sorry, August the 12th, jeez. August the 12th. Okay?
Sounds good.
Have a good
Yep.
day, guys.
Thank
Good
you, sir.
luck.
Thank you, Your Honor.
Thank you, Your Honor.
Well, it just so happens that today is August the 12th, so I hope he paid for it. This hearing was from a few days ago. So, anyways, that is it for today's episode of Second Session, but we're going to be back tomorrow with a full slate of programming for you. We have TCF Live at 9 a.m. Eastern. We have this show again tomorrow at 2:30 p.m. Eastern, and Sidebar tomorrow night at 8 p.m. Eastern. So all sorts of programming for you. In the meantime, go have yourselves a great day, and we hope to see you soon. Take care. God bless.